If President Trump's nominee to the Supreme Court, Coney Barrett, receives Senate confirmation, will this cause the Democrats to enact a court-packing scheme if Joe Biden is elected president? Join Richard Ebeling and me in this week's segment of The Libertarian Angle as we examine that question. Hi, I'm Jacob Hornberger, president of the Future of Freedom Foundation, and this is this week's issue of The Libertarian Angle, the show that brings you the principled case for the libertarian philosophy. I'm joined, as I am every week, by my co-host, Richard Ebeling, professor of economics at the Citadel and longtime libertarian. Richard, good to see you again for another round.
It's good to see you, and it's good to be with our viewers and listeners as we talk about another important issue of the day. I guess this week we're going to be talking about the Supreme Court and the most recent nominee for the high office, likely to be voted on by the full Senate on Monday.
Yeah, it's a big issue that has created lots of controversy. Ruth Bader Ginsburg passes away. Donald Trump's the president. He has the authority under the Constitution to nominate a person to replace her. He has done that with Coney Barrett, who it seems to me by all accounts is one of the most qualified people to ever serve on the court. But of course, the Democrats are upset because when Obama tried to appoint, I think it was Judge Garland to the court, the Republicans who control the Senate and therefore the ratification, the confirmation of the nomination, held it up and said, no, we're going to wait for the next president to be elected, which they had every right to do under the Constitution. But the Democrats are saying, well, the same principle should apply now. There should be a delay. And if Biden wins the presidency, he should be the one that appoints the justice. Well, my position is that's not the way the Constitution works. I mean, Ginsburg just happened to die when Trump was still in office. And the fact is the Republicans control the Senate and they control the presidency. He has every right to appoint Barrett to the court. Well, one of the interesting aspects of the controversy, setting aside Barrett's philosophy, her concept of originalism and so forth, is the threat that Democrats are bringing up to pack the court if Trump goes through with this nomination and confirmation. And what do I mean by pack? Well, they're saying that they're going to add to the size of the court several more members so that they can then get their people in office, assuming, of course, Biden wins, that Biden will then appoint, 4 or 5 more whose votes obviously will counteract Barrett's, along with other Republican appointees on the court. And as you know, Richard, there's nothing in the Constitution that prevents them from doing that. The Constitution did not set up a set number of justices. We're accustomed to 9, but there's nothing that says that that's engraved in stone or anything. And so the Democrats would have the power to do that. Now, that, of course, is politicizing the court. It's essentially, in my opinion, turning the court into a legislative branch. And you get your people in there so that you can essentially do whatever you want. And rather than looking at the court as a way to interpret the law, it becomes a place where you're just appointing your lackeys in there to get your programs through. And what comes to mind for me is Franklin Roosevelt's infamous court packing scheme. As you recall, and when Roosevelt was in office, he was bringing all these alien programs to American life, programs that were based in socialism, like Social Security, fascism, like the Agricultural Adjustment Act, the National Industrial Recovery Act, along with their big propaganda campaign that went with the NIRA, the Blue Eagle. And the problem was, the problem, of course, was the socialist and fascist aspects of this. But the problem for Roosevelt is the Supreme Court was rightly declaring much of his program unconstitutional. They said that this is alien to our form of government. And if you look at some of Roosevelt's programs, like the National Industrial Recovery Act, it could have fit perfectly in Benito Mussolini's fascist Italy. the leader of Germany, Adolf Hitler, even sent Roosevelt a letter commending him on his policies and programs and saying that he was doing much the same thing in Germany. And public works, massive public works project, was a project that was common to both countries. So the Supreme Court was declaring much of this unconstitutional and said, look, this was never part of the framework for American life in terms of our political system, our governmental system. And Roosevelt was livid. I mean, just furious. And he said, how dare you, these 9 old men that are interfering with what I know is best for America. I'm trying to save America from the Great Depression. My New Deal will do that. And we can't let the Constitution interfere with me. Because what good's the Constitution, he suggested, if the country goes down the tubes. So he comes up after he wins the 36th election in a landslide. He comes up with his court packing scheme, where he's going to replace every justice over 70 with his justice, which would have knocked out or nullified essentially the 4 justices that were solidly, in opposition to much of his programs, along with a 5th justice, Owen Roberts. But it was infamous in the sense that Roosevelt encountered tremendous animosity and opposition to this, even among his supporters and the mainstream press. They said, you don't tamper with our judicial system. This is something that's sacred here. You're not going to politicize it. And of course, Roosevelt was shocked. But he ended up getting what he wanted anyway, because Roberts then started voting in favor of what had been the dissenters. That became the new majority in a 5-4 decisions. And then in the 1937 case of West Coast Hotel versus Parrish, a minimum wage case, state minimum wage case, the court effectively held that never again would they declare any socialist or fascist law in violation of the Constitution, specifically relating to the welfare state. And then as the 4 horsemen, as they were called, the 4 justices that were declaring much of this unconstitutional, as they started to retire or die, Roosevelt, who stayed in office, 3 terms plus, he started replacing them with justices, and that was effectively the end of economic liberty in America. So that was really, I think, one of the big instances of court packing in our history. I think there was another one during the Lincoln administration with respect to the legal tender laws. But for me, what Roosevelt did was absolutely infamous and repugnant, and it should be sending a message to everybody here that that's not what anyone should permit the Democrats to do if Biden is elected and Barrett gets nominated to the court or confirmed to the court. What do you think?
Well, let me sort of touch upon a number of things. One is the arrogance and the hubris with which both Joe Biden and Kamala Harris have dealt with this subject. Maybe the viewers and listeners recall that during the vice presidential debate between her and Mike Pence, a couple of weeks ago now, I guess, she was asked flat out whether she would support Joe Biden's or the left's suggestion of packing the court. And she refused to answer. She wouldn't give the voters a straight answer. And then a few days after that, Biden was directly asked about this by a reporter during an interview. And he told the reporter, the American people don't have a right to know. I'll let them know after the election if she's been appointed. Well, that's basically saying, I don't trust telling you what I would want to do because it might influence your vote for me. But I will tell you what I'll do if I win and this justice who I don't support is put on the court. That's basically saying, I'm going to do it if I get elected. Now, he's hemmed and hawed and tried to step back with evasiveness again. But this is basically the position. Now, why is this the case? Why is this so paramount? Now, I did not watch the whole hearings where Barrett was being interrogated by the Senate Judiciary Committee. You can only take so much of this stuff, and life is too short. But I did watch parts of it, and I did read the news summaries the next days. And what struck me the most was the nature of the questions. Not that they were particularly unique to this candidate going to the Supreme Court, but representative of a mindset today about the nature of the Constitution and the purpose of law. And that was, she was, at least what I caught on TV or read the summaries of, not once, certainly not a Democrat, and I don't think any Republican, asked her, what is the purpose of the courts vis-a-vis the Constitution? Why is there a Supreme Court in terms of evaluating pieces of legislation in terms of its compatibility with the duties and responsibility of the federal government as laid out in the Constitution, including the Bill of Rights? No mention of that. What was the focus? Would you be for or against voting the way I want the court to vote if you're on the court? That's all that they were concerned with. Okay. Now, a fundamental implicit issue in this, which you were raising just now, is that what is the purpose of the Constitution? Well, other than the general welfare clause at the beginning, there's no philosophic statement in the Constitution per se. But it's clear, as my understanding is of the founding fathers, that their purpose of the Constitution was to have an institutional structure that would serve to secure and protect the philosophical principles laid out in the Declaration of Independence. We hold these truths to be self-evident. All men are created equal. They're endowed by the Creator with certain unalienable rights, among which are life, liberty, and the pursuit of happiness. Government is instituted among men to secure these liberties. Okay, end of story. It's not to redistribute wealth. It's not to impose regulations on honest and voluntary transactions among members of the society. It is not to impose a curriculum of indoctrination on young people in schools or to propagandize in general to mold the population in particular directions. It is basically to be there, as the founding fathers has best understood it at their time, of what was necessary for a limited government to secure the freedom of the individual citizens. Was she asked about that? No. Would you be against or for preserving Obamacare? Okay. Would you be for or against Roe versus Wade? So basically, they were asking her, will you be willing to support the continuing intergenerational redistribution of wealth that is represented by Obamacare and other government health care programs? This is mostly the older people who end up needing health care support through these government programs compared to younger, healthier people who are working, just like Social Security is an intergenerational tax. Was that raised? No. So what this is really is the court is viewed as a battleground, either to reinforce or challenge the ideological preferences of members holding political office. And if that is how the Constitution and its purpose and those who are supposed to uphold the Constitution on the Supreme Court are viewed, then basically we do not have a Constitution. What we then have is an unlimited democracy in which whatever majority has elected officials about promising certain things, then institute them, and the courts are just there to rubber stamp them and to serve a political ideological purpose. And if this then is reflected in a packing of the court, which might very well occur if Biden wins and the Democrats gain control of the Senate, if this leads to a packing of the court, then in fact we no longer have an independent judiciary, which was one of the reasons why the Democrats in the 1930s, even those loyal to him, opposed him on the court packing cases. We no longer have a separation of powers. It's one branch controlling another by the ability to add people onto the court to get the votes that he wants. And this is just another nail in the coffin of a properly understood free society and the political institutional structure needed for its preservation.
Yeah, I think you raise a really fascinating point. That they had this opportunity there in the confirmation hearings to really delve into the purpose of government and what was the type of government that was brought into existence with the Constitution. You hear some critiques sometimes that that Barrett's going to block the majority from doing what it wants. Well, that's the whole purpose of the Bill of Rights, is to protect people from majority rule. I mean, look at the First Amendment. It says, any law enacted by Congress, the Congress shall not have the power to enact any law respecting religion or freedom of the press or abridging these things. And well, so even if 98% of the American people enacted a law saying all parents must send their children to church, just like sending their children to public schools, the First Amendment prohibits that. So we don't want majority rule when it comes to fundamental rights. That fundamental rights trump the majority rule. That was the principle. And the same thing with the Second Amendment, the right to keep and bear arms. And so when the framers brought into existence the federal government with the Constitution, let's assume they had left the judiciary out of it. And all you had was a Congress and a president. Well, they understood that this was a tremendous threat to freedom, that Congress could enact laws, the president signs them into law, and that force people to go to church and their kids to go to church, that puts people in jail for dissenting, for criticizing the government, for assembling, for protesting, for having guns. And they said, no, this will be a limited government. But how do you enforce such a thing? I mean, suppose the Congress does pass a law forcing everyone to go to church, or making a criminal offense to study libertarian books. How do you enforce it? Well, that's the purpose of the judiciary, that people can go into federal court and get an injunction stopping the government from enforcing these laws. If you don't have a judiciary, then you don't have any enforcement mechanism. Then it's just trusting Congress to do the right thing, trusting the president to do the right thing. And that's not what this government was born in. It was not born in trust in government. It was born in distrust of government. Now, interestingly enough, they don't expressly say that the Supreme Court had the authority to declare laws unconstitutional, but that was the implicit idea behind it. And then, of course, it was assumed by the Supreme Court. I think the case was Marbury versus Madison, where they said, we have this authority to declare these laws unconstitutional. And it's a prerequisite to freedom. If you don't have the court declaring laws unconstitutional, then you don't have a free society, because then, as you point out, the Congress and the president can do whatever they want and destroy freedom to their heart's content. So you have to have a judiciary that is courageous enough to stand up against these two branches, and that that understands what the principles of freedom are involved here. And for the first 125 years, you had a lot of justices there that understood that was the purpose of the court. That starts to shift into the Roosevelt administration, where the philosophy then becomes, no, the majority, we need to defer to the majority. This is a democracy. Democracy means that the majority rules. And so after 1937, the government, in terms of economics, could essentially do whatever it wanted to: regulate, manage, control economic activity, business activity, and none of it was ever going to be declared unconstitutional. And then, interestingly enough, when the national security state came into existence after World War II, the court immediately, or almost immediately, started deferring to their authority and essentially said, we're not going to interfere with anything the Pentagon, the CIA, and the NSA are doing. In other words, they abrogated their responsibility to declare what they were doing unconstitutional. Why? Because they were just too powerful. The court knew that they could never enforce their judgments on the Pentagon, the CIA, and the NSA. So when the troops are sent into Vietnam without a declaration of war by Congress, which is required by the Constitution, the Supreme Court says, we're not going to get into this. This is non-judiciable. This is not something we're going to delve into. The state secrets doctrine. The Supreme Court develops that as a judicial doctrine in deference to the Pentagon. It wasn't a legislative act as it's done in other countries. The Supreme Court said, in a particular case, we're going to let this doctrine be implemented by the military. So that was these are the two big problems that happened in the 20th century. The virtually total deference to the national security state by the Supreme Court, and the deference to them in economic activity, specifically the welfare state and the managed economy.
Well, another way of saying what you're saying, let me suggest, is that if you read accounts by either many American authors and writers of the 19th century, and certainly foreigners who came to the United States either on visits or to settle here permanently, the word that one constantly sees repeated in their essays and books is the word liberty. And by liberty, they mean the individual autonomy of the person to peacefully and honestly live his life as he chooses in associative relationships with others without infringement or prohibition or restriction, as long as he does not violate the rights of another. That is the broadest theme of these writers of the 19th century in America, certainly the early and middle parts of the 19th century. Liberty is what America is about. Now, did they also talk about self-government? Yes, but they meant self-government in two ways. One, the self-governing individual running his and managing his peaceful and honest life. And then there was the self-government of a government being reflective of the wishes of the people through an election process. But it was clear that even though some did, but even if the adjective wasn't added, the presumption was their notion of democracy was a liberal democracy. And by liberal, they meant the philosophy of individual freedom, and that democracy is a way by which people vote to elect those who will hold office to enforce the laws in the pursuit of the liberal idea of personal freedom, not an unrestricted democracy of whatever the majority wants, or any coalition of minority groups that can form a majority on election day can proceed to run roughshod over others in society, that is, minorities in the society of various and sundry types. Today, one rarely hears the word liberty spoken in political debates, discussions, or arguments. Everything is about democracy and the will of the people. In other words, a conception, whether stated directly or not, of the idea of unlimited power to the will of a majority. It can be seen in the way the Democrats have responded in several elections now to the outcomes of presidential votes, where you've had a candidate who has won the Electoral College, but not won the popular vote. That has occurred now in two instances, Bush versus Gore, and then Trump versus Hillary Clinton, where according to the numbers, for example, Hillary Clinton had 3 million votes more than Donald Trump, but he had the majority of votes in the Electoral College, adding those up from the states in which he had won. And for them, this is abhorrent. But what is the purpose of the Electoral College? Well, it was clear if you read the Madison's notes of the Constitutional Convention and discussions of it afterwards, it is to see that you cannot have one or two or three places in the United States that merely because they have the most numbers of votes, that they can dominate the rest of the country in terms of its fate. Now, I would also say that there, in my opinion, there's a degree of blatant pragmatism here on the part of the Democrats and quote the progressives, who are calling for the end of the Electoral College and just pure national majoritarian decision making. Suppose that the vote had been opposite 4 years ago, and that Trump had gotten 3 million votes more than Hillary Clinton, but Hillary Clinton had won the Electoral College and therefore was now sitting in the White House. Would the Democrats be walking around with sackcloth and ashes? Oh, well, we haven't. Yeah, she won the Electoral College, but we have an illegitimate president in the White House. Really, by democratic principles, Trump won. Oh, and would Hillary have said, you know, I know I won the Electoral College, and even though I didn't win the majority vote, right, the will of the majority, I therefore am going to defer and let Trump become president instead. Would they have done that? No. So in one sense, it's political circus and just rhetorical opportunism. But underneath this is the idea that it's just the will of the majority. the will of the majority. Now, of course, there's a hypocrisy also in the case that their interpretation, that is the Democrats and the progressive left, is that they're for the will of majority only for as long as the majority support them. Now, the fact is, for decades, there have been majorities of Americans who have voted for candidates or supported policies in referenda that go against what the progressive left want. And when they can't get the majority they want in an issue, that's why they want an activist court. They want an activist court that will supersede the wish of a majority when the majority doesn't go their way. So this is all political power play and rhetorical hypocrisy, because it's basically saying, I want this power to dictate how people will live and how government will impose its paternalism on the rest of the society. And if I don't get my way through an election or through an advise and consent process in Congress, well, I refuse to play by the rules, I'll just change the rules. And that's what we're facing today.
Absolutely, regardless of who gets elected, they both believe in the welfare state way of life. They both believe in the warfare state way of life. But you know darn well that if Biden's elected, we're going to see a tremendous expansion of welfare statism in America, regulations, controls. And the problem is that the court is going to defer to them. They're going to sustain it based on this historical legacy that goes back to 1937 and Franklin Roosevelt, just deferring to the will of the majority that, well, the electorate spoke, and now if they want to have a minimum wage of $15 or $20, that's just the way it has to be. Well, before this, when you go back to this era up to 1937, as I mentioned earlier, there were 4 justices who took this principled stand that it doesn't matter what the majority rules. If the majority rules in a certain area that it violates the Constitution, then it's got to be nullified by the court. And I would invite listeners or viewers to this program to go and study or just read the opinions of these 4 dissenters, or sometimes they were in the majority when Owen Roberts was with them. They were Sutherland, Vandivanner, Butler, and McReynolds. Their opinions are very, very principled in terms of what their duty is as justices. Very, very eloquent. They make it clear we're not here ruling on whether this is beneficial or not beneficial to society. That's not our job. That's Congress's job. Our job is to look at the law, look at the Constitution, and say, are these consistent with one another? And if they're not, then it doesn't matter what the majority says. Now, one of the other interesting aspects of this controversy is, the Bill of Rights applied only to the federal government. The way the original government was set up, the states had the authority really to do whatever they wanted. If they wanted to confiscate guns, if they wanted to force people to go to church, there was nothing the Supreme Court could do about that. I think the only restriction was that they had to maintain a Republican form of government in the Constitution. But other than that, they had the authority to do whatever they wanted. Now, granted, most of them didn't do it because they had this philosophy of freedom and they had state constitutions that limited their power. But then along comes the 14th Amendment that then gives the Supreme Court the power to declare state laws in violation of the Constitution. And that's where these minimum wage cases were originating oftentimes in the 30s, and maximum hours legislation like in Lochner versus New York, where somebody would sue or get criminally prosecuted and it would end up at the Supreme Court. And the court could say, we now have the authority to examine state laws and what the majority is doing in the states and decide whether that violates the Constitution. And I think that was a tremendous boon to liberty, that people then had 2 bites at the apple, that they could argue either in state court that this law violated the state constitution, but they could also argue in federal court or in state court that this violated the federal constitution as well.
Yeah. But all of this is indicative of the entire trend of the last more than 100 years. And that is a shift towards the notion of political paternalism, where it is the duty and the responsibility of the government to regulate and redistribute, to serve some notion of the common good, the general welfare, as normally defined by an elite. And this elite presumes to know what is right for the society. Now, it's elites on the progressive left and elites in the conservatives. I mean, the fact is that, yes, the progressives wish to regulate us in the marketplace, but it is a long history that is the conservatives who want to regulate our personal conduct, with whom we interact for various personal and intimate activities as consenting adults, notions of moral compulsory teaching in the society, and certainly in this venue, as many conservatives are pushing now, that the federal government should be controlling or prosecuting social media outlets that are private companies. Now, I happen to agree with some of my conservative friends that the case that Google and Facebook are clearly choosing to bias how they offer material or to restrict certain people in their social media venues from expressing certain views. The problem is that these are private enterprises, and it is not the role of the government to tell a person how to run their business, including if they choose to not allow the expression of certain views. Once you let the federal government in through that back door, then it is just another way of government control and manipulation, and then in various settings, prohibitions of freedom of speech. A lot of people say things that I don't agree with or approve of, and I might find even morally repugnant. But in a free society, the way you oppose that is by reason and persuasion and developing other venues to express your views if you can't express it through others. The worst method of this is to believe that because you don't like a way a person is allowing or not allowing expression of views, you will then turn to the state to regulate, control, prohibit, or ban. And that is a theme that these conservatives have, or at least some of them, that is very dangerous because it always needs to remember that's a two-edged sword. Once you have the federal government telling what what not, something such as Facebook or Google can offer or not offer, then what happens when the other side is in power and they decide to do it the other way? So this is a dangerous precedent, and both are guilty of this paternalistic interventionist mentality.
Yeah, I mean that's why I say, regardless of who you elect, you're going to get it one way or the other. I mean, look at conservatives in the drug war, supporting massive violations of the Fourth Amendment. I mean, if you look at the case law that has developed in the last 50 years on search and seizure, most of them are drug cases, and massive infringement to justify what the conservatives and of course the liberals want to do with the drug war. And then you've got all the foreign interventionism, and that used to be a conservative project, but now the liberals are just as much enthusiastic about foreign interventionism as the conservatives, and we all know that where that leads to the destruction of liberty. So what we really need is not only an enlightened citizenry that is devoted to genuine liberty in terms of libertarianism, but we need a principled activism by the Supreme Court, where their job is to look at these laws and say, no, this violates this charter called the Constitution. And unfortunately, we're being hit in both directions. We've got two political parties supported by masses of people that want the government to have these enormous powers over our money, our economic activity, and then to rule the world through the Pentagon, the CIA, and the NSA. We got our work cut out for us, Richard.
Yes, I'll just add on that last point about the foreign policy, is that it's often been presented as the conservatives who are the hawks, the pro-foreign interventionists, and they have been through much of the Cold War. But notice what is upsetting the progressive left. You see this in publications such as the highly respected Foreign Affairs Quarterly, which has articles all the time online, and it's the idea that Trump has undermined the global order by saying and partly trying to pull back from America's leadership role in the world community. And what we have to right now restructure and recreate under a Biden presidency is America's leadership and participation in global affairs. So it is the progressive left who wants American diplomatic and implicitly military activism in the international scene. And in fact, they're the major pushers for this right now, far more than conservatives, though the conservatives have their own series of sins of the past and the present.
All right. On that eloquent note, insightful note, we'll wrap things up. This is this week's segment of the Libertarian Angle. If you're new to FFF, this is your first exposure, come and visit us at fff.org. Subscribe to this YouTube channel. And Richard, greatly enjoyed the conversation as always. Look forward to talking to you next week.
Until next time.